Good afternoon, everyone. Thank you for joining us, coming from signing room 3 at Kelly Santini's office in downtown Ottawa. Delighted you're spending your lunch hour with us. Grab a sandwich, grab a drink, and Mitch Kitagawa, our speaker today, is going to take you through some of the interesting legal cases from the insurance sector from 2015. Mitch is a partner with the Insurance Defense Group here at Kelly Santini. My name is Keith Gallup. I'm the Director of Client Services, and I will do my best to moderate today's discussion and run the technology. That'll mainly include me keeping my fingers crossed a lot, but looks like so far so good, and it's great to have so many of you logged on to join us today. Mitch is going to take you through some cases for the next 35, 40 minutes, and then, of course, we'll spare some time at the end to take any questions that you have. There is a dialog box on your screen where you can type in any questions, and we'll likely just go through the presentation and then get to the questions towards the end.
Or we'll delete them.
Does that work? Does that work for you, Mitch? Yeah, it depends on the question. Hopefully not too challenging, but we'll certainly, and whatever questions we don't get to, we'll respond after the webinar. Mitch actually gave this presentation a few weeks ago at the Insurance Institute, and it was called the Legal Roundup, so he wore a cowboy hat. And I just wanted everyone, as he's talking today, you can imagine he's wearing the cowboy hat again. So, Mitch, I will turn things over to you.
I've got the chaps on too, so they can't see that. Thanks for the introduction, Keith. Thanks for setting all this up. As Keith Gallup is of Temple Partnership, templepartnership.com. This is my first commercial of the day. templepartnership.com. So if you need someone to promote your business,
this webinar brought to you by
this organization is the one to look at. So Keith said, grab some lunch. He forgot to mention coffee, maybe a Coke, something with some caffeine in it. But we'll get through this. Now, I was told I would have an hour to do this. I would have to speak for an hour, and that made me feel bad for you. Actually, I won't be an hour, but I know it'll seem like it. So I'll start with my favorite insurance joke. Now, if people have heard me speak before, they'll have heard my joke before, but it's funny because it's about a lawyer. A lawyer and an insurance broker sitting by a pool in Florida. And the lawyer says, "I'm here because I had a fire in my house. My insurance company paid for all the junk I kept down there in the basement." And the insurance broker laughs and he says, "Me too, but I had a flood." And they pause for a moment. The lawyer turns to the broker and he says, "Hey, how do you start a flood?" I can hear the peals of laughter. I can hear them. All right, so howdy. This here is the legal roundup. I don't know why they call it a legal roundup, but I've seen that used in different places. And so I don't know why the Western ring to it. So when I Googled legal roundup images, you can see here I got weed killer and I got the cowboy theme. So I'm going to talk all Western through this here presentation. You know, it's funnier when you can actually see me because I'm Asian. That's right. We got through that, Keith. Poor Keith is dying because I just said that. All right. Well, my talk is going to jump around quite a bit. Some topics will be of interest to you, others not so much. So because I can't see you, feel free to send texts and emails, when there's something that doesn't interest you. Usually when I talk at a live venue, I can see people looking down and smiling at their crotch, and I know they're not thinking about me. They're checking their emails. So I tell them, go ahead, send your emails if you're not interested in a particular topic. In fact, I may do the same thing if I find I'm losing interest in what I'm saying. So if you hear a gap in the middle of the presentation, I'm looking down at my crotch and smiling. All right, so I think Keith is going to shut this down soon. I got my BlackBerry here. I know it's a BlackBerry. I had my car broken into. They took everything and they left the BlackBerry, yeah, and a condolences card. Insulting punks. All right. So the way I'm going to go through this is I'm going to cover a couple of cases, and then I give you a few short and sort of snappy pointers to remember. Most of the cases that we're doing are sort of practical based. It's things that certainly adjusters and brokers can do, or just keep in the back of their minds when they're handling files. I'll remind you later, but something that I tell everyone that I speak to is that if you have a quick question about an insurance issue, feel free to call me. I'm happy to give you a quick answer, or if you just want something confirmed, just give me a call. I'm happy to discuss it with you. Don't worry, I won't charge you for it. I'm happy to help out. An example is I had an adjuster in Southern Ontario call me to ask me if a polar vortex is one event or if each day is a new event, so that each day a pipe bursts in a different part of the building. He wanted to know if he could apply the deductible. I thought that was a great question, and I don't know if you know what the answer to that is, but I looked it up and there were cases, and the courts basically say that the polar vortex is one event, so only one deductible would apply. It's a great question because I hadn't come across that before, and it only took me a few minutes to research the answer. So, don't be afraid to call. Now, I've got one final commercial to do, and that is that our firm is part of a group called Risk Management Counsel. And what is it? Why should you care? Well, because at some point in your careers, I suspect you'll need a lawyer in another jurisdiction than the one in which you operate. And you want to know who are the insurance defense firms that you can speak to. So this is a group of independent insurance defense firms right across the country. So if you ever need any legal assistance in another province, you can just call them directly, or you can call me, and I can put you in touch with someone in the province in which we operate. So I'll put you in touch with one of our partners. We also have webinars that we put on, for which I believe you can get credits in certain provinces. Is that right, Keith?
You can, yeah.
So you can just go to the website and sign up for our newsletter and other case law summaries. It's a good resource. We had a lot of hits on our website for the cases. So again, just keep that in the back of your mind. As I say, it'll come up at some point in your career. So if you're looking for that resource, you may want to refer to RMC. All right, so we're gonna get you're too early. That's all right, Keith. Don't worry. That's all right. When I was going to law school, the best thing about the cases that we learned were learning the facts. And they were always sad, or they were funny, or they were ironic, but they were always interesting. And it kind of reminded me of a joke that my 12-year-old son told me. He said this guy decided he's going to go to the prom, so he went to rent a tux, and there's a big lineup. And he waited, and he got his tux. Then he went to rent a limo, and there was a big lineup, but he waited, and he got his limo. He picked up his girlfriend, and they went to the prom. And while they were there, he asked her if she wanted something to drink. She said that she did. So he went over to the bar, and there was no punchline. So, you get these great facts, and then it's the judge who writes the punchline years later. All right, so let's get to it. That's a good intro. That's good. Yeah, you can leave that up for a second there, right. Keith. So the first case I'm going to cover is one called Sant versus Sekhon. It's a bodily injury MVA case. So property people and brokers, you can start texting. I can just see click, listening to boring webinar. Do you need me to pick up milk on way home? Send. So this case is Sant versus Sekhon. So let me set the stage for you. It's May 20th, 2005. It is 7 p.m., so it's still light outside. And Mr. Sekhon is driving his truck down a busy street. He's approaching an intersection, and he sees that the light is green for him. And so he proceeds through the intersection. Now, we know there's a collision coming, right? Now, some witnesses, like the driver behind Mr. Sekhon, said that he thought the other vehicle driven by Mr. Sant was not going to stop. Likewise, another driver who was stopped for the red light saw the Sant vehicle and didn't think it was going to stop for the red light also. To make it even more confusing, some witnesses say that the Sant vehicle stopped at the red light and then proceeded through, or that the vehicle at least slowed down and then drove through the red light. What everyone agrees upon is that the defendant, Mr. Sekhon, had a green light when driving through the intersection, and Mr. Sant, who proceeded into the intersection and in front of Mr. Sekhon's truck, causing a serious accident, ran a red light. So case closed. Thanks for coming out. Wait, the jury said what? In his charge to the jury, Justice Ricchetti told the jurors that while there's no doubt that a driver going through a green light has the right of way and a driver with a red light should stop, the rule that applies over and above all else is that all drivers must exercise reasonable care when operating a motor vehicle in all circumstances. This means if they have a right of way or not. Now, in this case, the jury found that Mr. Sekhon was 5% responsible for this accident. And I looked at it and I thought they must have figured that the fact that witnesses around Mr. Sekhon thought that Mr. Sant was not going to stop meant that Mr. Sekhon should have seen that Mr. Sant was not going to stop and could have done something to avoid the accident. The Court of Appeal upheld this decision, suggesting that if a driver can see that an accident will happen, if he or she asserts their right of way, or they can avoid the accident by taking some maneuver, even though they don't have to, they will be partially liable for the damages. So what does that mean for you? Well, if you're investigating the accident, you want to know if the driver with the right of way could have or should have known that the accident could occur if he exercised his right of way. So what were the sight lines? What did the other witnesses say? What was the timing and speed of the vehicles and the lights and the weather? Don't just assume it's a 100% liability case because one party had a red light and the other party had a green light. If you're setting reserves and you think that you're scot-free because your insured had the green light, you may want to be a little more cautious in that regard, depending on the facts, and set your reserve accordingly. All right, now I'm going to move to another case. It's called Van Berlo versus AIM Underwriting. This is a BI case, it's a property case, and these facts are kind of fun. Has anyone ever had sweet potato fries? Mr. Van Berlo was the leading producer of sweet potatoes in Canada, and that has absolutely nothing to do with the facts of this case, but I thought it was interesting. Anyways, well, actually, no. Sweet potatoes did allow him to be able to afford his own plane. It was a double-engine, 6-passenger Piper Aztec. One day, he flew some fellow American farmers back down to North Carolina, and he was on his way back when he stopped in Brantford, Ontario. Now, his home was about a 6-minute flight away, and I imagine he had an airstrip on his farm or something. I hope. But after I read the facts of this, I was not so sure. Anyways, so he's getting ready to fly back home from Brantford when he noticed that one of the 2 engines on his plane was not operating. What might happen here? Well, the plaintiff, Mr. Van Berlo, claimed that despite the fact that he only had 1 operable engine, he was 100% sure that the flight would be successful. What I found amusing about this case was the fact that Mr. Van Berlo testified that he was going down the runway, the second engine cut out, and it was too late to stop. He could not get the height that he needed to get over some trees. His wing clipped some trees, and then he intentionally caused the plane to cartwheel to avoid it nosediving, which would have had deadly consequences. I mean, this guy must have been an amazing pilot. But wait. The defendant's witnesses describe a takeoff in which he veers off the runway, goes across a grassy patch, goes across a taxiway in which he takes out some equipment, then onto another grassy patch, and then he takes off. What they're saying is that he should have stopped the plane once he knew his takeoff was a little unorthodox. The defendants denied the claim for property damage because they said that the crash was not an accident. They didn't exactly say what they thought, but it was not an accident. I guess it had to be intentional. Anyways, the judge looked at the policy and said that it covered, quote, occurrences. Everyone can see my air quotes. I've got 4 fingers up in the air like 2 little bunnies. Keith, I said 4 fingers in the air, not that one. So the occurrences include accidents, but the word accident was not defined. So he found that an accident is an unintended consequence of actions. And he said, and again, I got the bunny quotes up here. So this is reading from his judgment. And so imagine the facts as I'm reading this. I conclude that the plaintiff's decision to attempt a single engine takeoff was foolish. It was bad judgment. It amounted to negligence. I'm unable to agree with the defendant's submissions. There may be circumstances where a 1-engine takeoff in a twin-engine aircraft can fall outside the scope of an accident. It's not for me to speculate as to the circumstances where that may occur, if at all. It cannot be said on the facts that the plaintiff realized the danger of his actions and deliberately assumed the risk, nor can it be said that the plaintiff's conduct rose to a level of recklessness or culpability such that the occurrence was no longer an accident. The defendants made submissions that the path of the aircraft supported their position. I disagree. Issues regarding the path taken by the aircraft were discussed earlier, and findings were made. The damage to the marker was a minor incident. The time spent by the aircraft on the grassy infield areas was not significant given its speed as it was approaching the point of being airborne. I accept that it may not be normal to veer off a runway during takeoff. However, I find that the path taken by the aircraft is a product of the plaintiff's negligence in attempting a one-engine takeoff. It does not render the occurrence one which falls outside the scope of an accident. End of quote. So ultimately, the court found that you can be negligent even if at the time you don't think your actions were negligent. But it's not an accident where the person realized the danger of his actions and deliberately assumed the risk. I read this case. I felt bad for the defense lawyer. I could see myself, if I were assigned the file, sitting there and reading the facts and saying to myself, so a plane designed to fly with two engines. Now, to be fair, there was evidence that it could fly with only one engine, and the pilot had flown it with one engine before. But a plane designed to fly with two engines only has one. And the pilot knows it, but he figures he'll try to take off anyway. Like, surely he knows the second engine isn't a spare. Do you really think he never considered the fact his plane would crash, but maybe he was just taking a chance? You know, there's a saying, there are old pilots and bold pilots, but there are no old, bold pilots. I'm not a pilot, but if I started down a runway, my plane swerved off the runway, I'm pretty sure I would shut it down. So it seems that the definition of accidents is in the head of the insured. He just has to say he didn't think it would happen, and it's an accident. Don't bother with what a reasonable person should think. It's about what the insured thought at the time. And it's a little ironic, I think, in the last case about the guy who had the green light and he was told he was liable because even though he thought that he had the right of way, someone else thought that he should have stopped and he should have known he could cause an accident. And then in Van Berlo, it doesn't matter what others think. It's all about what the insured thought. Anyways, your takeaway from this case is that where the word accident in a property policy is not defined, it will depend on what the insured thinks at the time as to whether or not the occurrence was an accident. I'm going to go on to another case now. This one is Douglas versus Stan Ferguson Fuels Limited. And you know, I think I misspelled Ferguson in this one. I was checking it online and it had Ferguson spelled with two S's. So I'm not sure if that's right or not. But anyways, if you put in Douglas versus Stan Ferguson, you'll find it. This case is a subrogation case. And it's going to be the only time I'll talk about a subrogation case. There really aren't too many that come along that sort of have novel points. What I liked about this case is that it brought together subrogation and bankruptcy law, and that's a little bit unique. It's a local case to Ottawa, and someone listening to this may even have been involved in it. The facts start as a run-of-the-mill oil spill on property that was owned by Mr. and Mrs. Douglas. They were insured by State Farm. State Farm, using the Douglas's name, sued those involved in providing oil to the property, including Stan Ferguson Fuels. Excuse me. What we find out is that the Douglases were going through a marital separation and an eventual divorce. Mrs. Douglas had moved from the property prior to the oil spill. 1 year after the spill, Mr. Douglas entered into bankruptcy protection, and then State Farm began reporting to Mr. Douglas's trustee in bankruptcy and the mortgagor's lawyer about the cleanup and the amounts being paid. The contents claim was settled with Mr. Douglas, and when the remediation of the property was complete, the trustee in bankruptcy wanted to sell the property. And when State Farm started its claim, Mr. Douglas was still in bankruptcy. Now, one of the things to know about bankruptcy law is that when someone goes bankrupt, the trustee takes over the bankrupt's estate. So Mr. Douglas's affairs were taken over by the trustee. The defendants were pretty smart, and they claimed that as a result of the bankruptcy, State Farm could not commence the subrogated action. It had to be the trustee in bankruptcy. It goes back to that expression that in a subrogated claim, the insurer only has the same rights as the insured. If the insured is bankrupt, it can't bring an action without the consent of the trustee. So the plaintiff does not have capacity to bring an action. Well, Justice Abrams said no way. He cited decisions in which the court has said that subrogated claims exist to bring the wrongdoer to account for the damages caused. So he dismissed that part of the motion. The defendant then brought leave to appeal before Justice Hacklin. And Justice Hacklin agreed that the appeal should go to the Court of Appeal. When I read Justice Hacklin's decision, I got the impression he strongly disagreed with the decision. In fact, he said just about as much when he quoted the Court of Appeal, who said, "There is no doubt that an undischarged bankrupt cannot bring action to enforce property claims." Now, as we sit here, the appeal court is deciding what to do with this. I communicated with one of the lawyers this morning who brought the appeal to the Court of Appeal, and she said that she was given a rough ride on her appeal. She's on for Ferguson Fields, of course. She thinks she'll still get the decision. I wondered why she got the rough ride. I wondered if maybe it was because Justice Hacklin had almost, as I say, written the Court of Appeal's decision on this, saying that the motion judge got it wrong. So we don't know exactly what the end will be on this particular case. But what I think comes out of this is that if you find yourself commencing a subrogated action and the insured is bankrupt, make sure you get approval from the trustee in bankruptcy. And of course, if you're defending, make sure that the trustee in bankruptcy has agreed or directed the claim. I know it's a unique situation, but it's a reminder about how aware we all have to be about different areas of law that can affect what we do. Well, now I want to move to what I call the lightning round of our presentation. So these are those short, snappy points I wanted to remind you about and which are current. I'll ask a question and you can yell out the answer. I'm just kidding. I can't hear you. So the first thing I thought I'd remind people is that, excuse me, for bodily injury, the new deductible amounts for MVA bodily injury claims as the inflation rate is now applied. So effective August 1st, 2015, the Insurance Act and the Ontario regs have been amended to reflect that the $30,000 deductible for general damages will now be adjusted yearly for inflation. So the period August 1st to December 31st, 2015, the amount will be $36,540. That's your deductible. On January 1st, 2016, and every subsequent year, the amount will be revised and then published in the Insurance Act. The $15,000 FLA, so the Family Law Act deductible, will be adjusted yearly for inflation as well. So again, for the period August 1st, 2015 to December 31st, 2015, the amount will be $18,270. And again, on January 1st, they'll revise the FLA deductible and include that. The monetary threshold at which the deductible no longer applies. So you'll recall that it used to be $100,000. Any general damage over $100,000 would not have a deductible applied to it, and it was $50,000 for the FLA claimants. It's now been adjusted. So from August 1st to the end of this year, the amounts will be $121,799, and for the FLA claim, that threshold is $60,899. There's a new case that just came out, Cobb versus Long, and no, it's not on there, Keith. I don't, Keith, want to change the slide. So this is a new case that came out just recently. It's out of Kingston, and it was Justice Belch who heard it, and he was looking at the application of the deductibles. And the question was whether or not the deductibles were applied retroactively, or if they would apply from August 1st, 2015, based on the date of the accident. And we're going to talk a little bit about that later when we talk about interest rates, but it's sort of the same thing. You'll hear this debate about substantive versus procedural issues being argued with respect to the application of either the deductible or the interest rate. And so if it is substantive, then it is not retroactive. And if it is procedural, then it is retroactive. And in this case, and it's the only case I know of, Justice Belch found that these new deductibles are applied to those accidents which occurred on or after August 1st, 2015. So if you're trying to settle a case now, which for an accident that occurred prior to August 1st, you won't be able to apply the new deductibles. All right, one more short, snappy point, and I think I have that on there. Give it a click and see what happens. Okay, that was the next one for deductibles. Yeah, okay. So for typical commercial property policy, what is the limitation period for an insured to sue the insurer? And the answer is 1 year. I know some people realize that it's 1 year. You have to have the statutory conditions attached to the policy, and it has to say that the statutory conditions apply to all of the property part of the policy. As long as it does that, then you'll see it's 1 year, as opposed to what everyone thinks, or what many people still think is a 2-year limitation period. And that happened because the Limitations Act was changed in 2006, I believe, to allow businesses to change the limitation period on agreement. And so because commercial policies are typically with businesses, and the insurer is a business, therefore they're allowed to amend the limitation period. So that's how it gets amended without being stuck by the Limitation Act. All right, let's go back to a couple of cases here. I'm going to talk about O'Byrne versus Farmers Mutual. There's actually nothing particularly shocking about this case, and maybe not even anything new, but I think it's always important to remind people who are handling files and dealing with the insureds about certain things, because they seem to crop up time and again. And this one would apply both to adjusters and to brokers on a more general in a more general way, but I'm going to talk about brokers in another case after this one. So in O'Byrne versus Farmers Mutual Insurance Company, Farmers Mutual insured a building owned by the O'Byrnes. It was an all-risks policy, and a residential tenant in their building tampered with the oil-fired furnace, causing oil to overflow and damage the main floor commercial units in the building. Farmers Mutual relied on an exclusion and denied coverage under the policy. An independent adjuster retained by Farmers Mutual wrote to the O'Byrnes and advised them that they were not required to deliver a proof of loss. Mr. and Mrs. O'Byrne initiated an action against Farmers Mutual for indemnification for the damages to their property. Farmers Mutual was denying the claim partly because the insureds were not compliant with submitting a proof of loss, among other things. And the trial judge found that Farmers Mutual waived the proof of loss requirement through their independent adjuster. Farmers Mutual appealed. The Court of Appeal dismissed the appeal and stated that there was ample evidence to support the trial judge's conclusion that Farmers Mutual waived the proof of loss requirement through the independent adjuster's letter. Farmers Mutual never disavowed the adjuster's letter, and in fact specifically referred to it when communicating with O'Byrne's legal counsel. Insurers and their agents must be careful when making representations to insureds. Whether it's with respect to a limitation period or providing a proof of loss, if the insurer indicates a waiver of any type, the court's going to enforce it in order to provide relief to an insured. Insurers and adjusters should insist on compliance with the insurance policy as it's written, unless it's willing to accept the consequences that flow from any waiver. However, if the insurer does waive a condition and wants to rescind it, it should indicate that it rescinds the waiver in writing and then sets a very reasonable deadline for the insured to comply with the condition, and then hope for the best at trial. So sometimes you want to play the nice insurer, the nice insurance adjuster, and you say, look, don't worry about getting us a proof of loss right now. You have to be sensitive to insureds who have not been through claims before, and they hang off of every word, and they don't understand our insurance language. You have to speak to them in simple terms and outline deadlines for them when they have to meet them. Your concern is not always what you say, but it's what could be inferred by the way you say things. So be clear and straight to the point. Don't hold anything back, even though it's you have to give them bad news. Give them the bad news. Try and use plain language. I know that we use terms like proof of loss, a schedule of loss. They don't know what that means. You have to explain that to them, and of course, try and confirm it all in writing. I'm going to move to another case called Corrigan versus Crain and Schooley. this is sort of tied into what we just what we talked about dealing with insureds. I like to speak about this case because it was mine and I won. Um, but it also surprised me. No, not because I won. It also surprised me that with respect to how they dealt with the brokers in this case, and I always felt that when you read this case, brokers may feel a little bit uneasy. So this was actually a summary judgment motion arising from a tarp barn that collapsed in December, excuse me, of 2012. Now, I don't know if you know what a tarp barn is, but it's basically a metal frame with a piece of plastic kind of stretched over. It's obviously heavier than a piece of plastic, but it creates a big shelter for things like livestock or grains, that sort of thing. So the tarp barn collapses December 2012. And when the plaintiff's wife contacted the insurer, she was told that they were not covered as, quote, again, collapse was not a, quote, named peril on their policy. The insurer went to the farm to see if the collapse was itself caused by one of the named perils, such as wind. However, upon the insurer's arrival at the property, the plaintiff denied him entry. Now, I know the insurance adjuster on this file. He's the nicest guy ever. And I can just imagine this angry farmer standing on the road, not letting our nice adjuster in. I'm sure he had a few choice words for him. Anyways, so the adjuster turns around and heads back. The plaintiff took no further steps with the insurer. And despite getting a letter from the insurer, they never filed a claim with the insurer, which is now Commonwealth. It used to be Lanark Mutual at the time. Instead, the plaintiff brought an action against the insurance broker, who had initially added the tarp barn to the plaintiff's existing policy back in 2006 as an outbuilding. The plaintiff alleged the collapse was caused by snow load damage and claimed it was negligent for the defendant, so the broker, not to have included this coverage on the original policy. The plaintiff claimed the defendant's actions amounted to negligence, a breach of contract, and a breach of the defendant's fiduciary duty. We argued that the plaintiff never made a claim through the insurer, so coverage was never fully determined, meaning an action against the broker was premature. Now, the judge, Regional Senior Justice Gordon, held that the brokers are expected to be more than salesmen. They must, 1, provide information and advice, 2, exercise a reasonable degree of skill and care while obtaining policies, and 3, advise their clients if they're unable to do so. So the judge found the broker breached his duty to advise the plaintiff, given the lack of evidence that any analysis as to what insurance was appropriate for his client was ever done, or that any advice was provided about uninsurable foreseeable risks. That's right. Where there's a named perils policy, you have to tell the insured what is not covered. And I don't know how you do that other than to tell them nothing else is covered other than what is in the named perils. And if they want more coverage, they better let you know. And again, don't just say it to them, write it so you have a record when they say later on that they thought they were covered for everything, which is what they typically claim. What I found frustrating about this case was that we filed evidence to the effect that you couldn't even find snow load insurance for a tarp barn. Think about it. Who's going to insure plastic stretched over this metal frame for snow load? Certainly in Eastern Ontario anyways. But the judge said it didn't matter. He said it was about whether the plaintiff knew that he didn't have the coverage, even though he had the policy in his possession. Now, the other part that bothered me about the claim was that the insured had never actually made a claim. And in fact, he might have been covered. The judge said he didn't have to file a claim to make the broker liable if he can prove the cause of the loss and then prove the cause of the loss would probably be one that would be denied. The problem that I have with this is that the insured had a way to find out conclusively if he would be denied, not just prove it on a balance of probabilities. All he had to do was make the claim. Doesn't seem that hard, but the judge said no. He just has to prove that the denial was probable. The reason we won was because the plaintiff could only use undated photographs and relatively vague Environment Canada reports to show that snow actually caused the tarp barn to collapse. There was no design specifications provided to suggest snow would be problematic or that the wind could be ruled out. And by refusing the insurer entry to the property, there's no opportunity for anyone other than the plaintiff to determine if there may be some other cause for the collapse. And he did not have the evidence to do so. So that was why he lost. He couldn't prove why the barn collapsed. All right, so what's your takeaway from that? Well, professionals will continue to be held to an extremely high standard of care. Professionals being you folks who are in the industry and deal with the public. In the case of insurance brokers, they'll have to let their clients know not only what perils are covered, but the perils that are not covered. Even if the insured doesn't make a claim against the insurer, the broker may still be found liable to the plaintiff. The best part of this claim, in my mind, when I was doing it, was the cooperation I received from other insurers who were willing to help out the broker when I asked them to swear affidavits to the effect that they don't sell all-risk policies for tarp barns. It showed a real camaraderie in the industry. So I hope if you ever get a call to help out a colleague, that you will take your time out of your day to do so, especially if it's me calling, begging for something. All right, so let's move on to another issue, and that's the issue of interest rates. As most of you know, the prejudgment interest rates have changed. Because interest rates have been so low for so many years, the government decided to change the interest rate for general damages for bodily injuries suffered in motor vehicle accidents. So the rules used to say that the interest rate was 5%. As of January 1st, 2015, the rate is now based on the prejudgment interest rate as described in Section 27 of the Courts of Justice Act. You might want to write that down when you're looking for the interest rate, Section 27 of the Courts of Justice Act. But it's not the rate that I want to talk about, of course. When Ontario changed the interest rate, it didn't enunciate how the interest was to be applied. And I had talked to you about this before with respect to the deductible. The question in the interest rate is whether it's retroactive to the date of the claim, or was it applicable as of January 1st, 2015. So there were two cases that came out. One was the Cirillo case. The plaintiffs wanted to accept an offer, but there was an argument as to how the interest would be applied. And so the court had to decide if the interest rate was a substantial right or if it was merely procedural. And as I'd said, if it's substantial, then the interest rate applies as of January 2015. But if it's procedural, the interest rate would be retroactive. And what the court found was that while the right to interest was substantial, the calculation of the rate was procedural. And as such, it felt that it should be applied retroactively. So the interest rates for all the actions that hadn't been settled yet in Ontario, the interest rate suddenly went down to something like around one. Well, I guess it would depend on when the accident occurred, that sort of thing, but when the claim was commenced. Then months later came another case. That first case, Cirillo, was interesting, surprised me because I didn't think that the courts would make it retroactive. Another lawyer in my office, Pat Santini, thought that they would make it retroactive. Then months later, another case came along. It's at the same level of court, the Ontario Superior Court, El-Khodr versus Lackie. And so Justice Toscano-Rocamo went through her analysis of the matter. And when I gave this speech previously, I realized that as I was explaining her rationale, it sounded like I was just rambling, so I'm not going to give it. So I'll get to the good part. And what I'll say is that what she found was that it should not be, interest rates should not be applied retroactively. So here we are stuck with two cases, Cirillo and El-Khodr, which sort of say the opposite thing. Now, the Cirillo case was taken into account when Justice Toscano-Rocamo gave her ruling on El-Khodr, but she just felt that it wasn't properly decided. So we now have two cases kind of hanging out there with respect to interest rates. And so what people have been doing, or what some people have been doing, and certainly what I've been doing is, because it hasn't been heard by the Court of Appeal yet, we've sort of been combining the two interest rates. So we've taken the 5% and as I say, the interest rate is around 1.3% now, and coming up with a midway point, which is about 3.15% is what I've been using to try and settle my cases. It hasn't really been a stumbling block yet, but you may want to keep that in mind when you're trying to calculate damages at this point. It's just a midway point. It's just a mathematical calculation, but it seems to be a fair one at this point. We'll have to wait until the Court of Appeal finally rules on one case or another to give us real direction as to how that interest rate is going to be calculated. All right, so since we're talking about interest rates, we're going to go back to the lightning round. A couple of quick facts, some things that people forget. The first question is the prejudgment interest rate based on the date of the accident? And the answer is no. The rate is based on when the claim was commenced. So that's when the rate is based. Remember, the interest calculation starts from the date of notice for MVAs, and from other bodily injuries, it'd be from the date of the event. So that's when it actually starts. Another quick fact to keep in mind, well, I'll put it as a question, kind of like Jeopardy. Do homeowner policies cover negligent misrepresentation? I know a lot of people think that negligence is covered, but it isn't. What is covered is actions in which there is either property damage or bodily injury. I may have that on a different slide. Click that over. Yeah, so what we see a lot of is, or what I have been seeing in the past, is where you have a real estate deal that's gone bad. So new purchaser buys a home, the basement fills up with water, and so then they sue the vendors, and they say there's negligent misrepresentation when you sold me that home. The vendors of the home then take that statement of claim and they hand it off to their insurer, and the insurers look at it, and some of them have been covering it and others have not. And the reason why they don't cover it is because the negligent misrepresentation on the part of the vendor isn't what caused the property damage. What it did was it enticed the purchasers to enter into the contract. Therefore, it's a pecuniary loss. It's not property damage, and it's not bodily injury. It would be different, of course, if they allege that as a result of the transaction, they suffered stress, and therefore it becomes a bodily injury. Or if they allege in the statement of claim that part of the negligence is the fact that they didn't fix up the basement properly if it had some repair done to it. And so therefore, their negligence with respect to that repair caused property damage. You have to ask yourself, is it property damage or bodily injury? Otherwise, it's not covered. All right, my next short and snappy one is snowmobile accidents. Snowmobile accident occurs in Quebec with Ontario residents. What law applies for liability? And what law applies for damages? So snowmobile accident is in Quebec. Ontario residents can expect that Quebec law for liability and Ontario law for damages. And the Quebec law is actually fairly similar with respect to liability as it is in Ontario. There are slight differences, though, subtle differences with respect to the owner of the snowmobile. Well, that's it. That's all I've got for this here legal roundup. Don't forget, if you have a quick question that you want answered, feel free to give me a call. If you need legal assistance in another jurisdiction, again, even if it's just a question, call me and I'll put you in touch with Defense Counsel in other provinces through our Risk Management Council, or you can call them directly. Again, just look on their, just take a look on their on our website. You can check it out there.
All right, thank you very much, Mitch. Right on time as expected. We have a bit of time for questions if anyone has any, and you've entertained us with a few jokes at the start. So your talk about the case with the farmer trying to take off with one engine reminded me of a joke when I was a kid. When I'm picturing the farmer on a flight going to crossing the Atlantic, and the joke goes: after takeoff, the pilot comes on and says, "Ladies and gentlemen, we lost number 4 engine, but that's okay. We still got 3, but we're going to be about half hour late." 20 minutes later comes on: "Ladies and gentlemen, we've lost engine number 3, so we're going to be about an hour late." Half an hour later, sure enough, the pilot comes on: "Ladies and gentlemen, we've lost engine number 2. We're going to be about an hour and a half late." To which point the farmer gets up and says, "Geez, if this keeps up, we're going to be up here all day."
Oh.
I don't even get a chuckle out of Mitch for
I'm
that
gonna remember that one for my kids.
All right.
So I can hear the groans.
The questions aren't pouring in, so we're going to let everybody get back and finish their lunch, finish their coffee, have their dessert, and return back to the office. But as Mitch mentioned at the start, any questions, by all means, please do send him an email. He's always happy to chat by phone. If you have a quick query, if you'd like a copy of the slides, you can let us know by email. A recording of this webinar will be posted up on our YouTube channel in the next day or two, and so it can always be accessed in the future or shared with colleagues. And with that, we will wish you all a very good day and look forward to talking to you again in 2016. And watch for the next issue of our risk report, which will be out in January.
Thanks, everyone.